Today we are going to be talking about the interaction between Medicare and nursing home abuse and neglect cases. My name is Barry Doyle. I'm a lawyer in Skokie practicing nursing home abuse and neglect work throughout the state of Illinois. I'm also the author of Built to Fail, a free report available for download from my website, which spells out how the nursing home business model inevitably produces unnecessary injuries and deaths for nursing home residents. Many, but not all, nursing home residents are Medicare recipients, whether it's by virtue of age or the fact that they have such significant disabilities that they end up on Social Security disability and end up eligible for Medicare. Either way, most but not all nursing home residents are in fact on Medicare. And Medicare is a federal program, and at the end of every nursing home abuse and neglect case, there is some obligation to reimburse Medicare for accident-related care. This is a very important part of the case, and it's something that is a part of the considerations in every negotiation to settle a nursing home abuse and neglect case. The federal government requires that we actually proactively notify them that we are pursuing some type of a personal injury action where Medicare has paid out money for medical expenses. It requires us to advise them of the date of the accident and the nature of the injuries claimed. At that point, we have an obligation, assuming that there is a settlement, to reimburse Medicare for accident-related care. We aren't obligated to reimburse them for other types of care. So the example I commonly give to my clients is that if somebody falls and has a broken hip, but they also have Crohn's disease, when they go to the hospital, they will get treatment for their broken hip, but they'll also get treatment for the Crohn's disease at the same time. Medicare is able to look at hospital bills and doctor bills and determine which parts of the bills that they pay are related to the Crohn's disease versus what's related to the fractured hip. And what happens then is that they send us an itemization which lists out all of the care that they paid for, which would be related to, in this case, the fractured hip. Once that happens, part of the service that we provide is that we review that itemization, make sure that they are actually claiming things that are appropriate and disputing anything that is inappropriate. Now, at the end of the case, there is an obligation to reimburse them for this accident-related care. There's no obligation to reimburse them for care that was provided before the date of accident. There's no obligation to reimburse them for care that's not related to the accident itself. The reimbursement obligation is based on the actual dollar figures paid out by Medicare, which is vastly different from the gross amounts that are billed by the hospital. We are still entitled to go ahead and claim the gross amounts billed, but our reimbursement obligation to Medicare is limited to the amounts that are actually paid out for Medicare, or by Medicare for the accident. Beyond that, Medicare accepts a reduction for a pro rata share of attorney's fees and costs that are incurred in making that recovery that Medicare gets of the money that they paid out. Effectively, what this means is that the reimbursement to Medicare amounts to about 60 to 65% in most cases of the gross dollars actually paid out by Medicare. So the final reimbursement figure to Medicare is often a small percentage of the care that's actually related to the accident. It is an important consideration in every case. It's not something that I recommend that people try to handle on their own. It can be a complex matter and really create a lot of problems if it's not handled properly. Hope this has been interesting. Thank you very much for watching. My name is Barry Doyle. You can reach us at 312-263-1080 or on the web at www.accidentlawillinois.com.